Welcome to the Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner. I appreciate your time and listening to this session. We are talking about asset protection. What does that actually mean? Well, we talked about in session 1, if you have some rental property, you need to put that liability protection fence around so you don't have unlimited personal liability for the claims of that tenant on a personal injury claim. That was number 1. Session number 2, we talked about the surviving spouse. So you structure things properly so all that money does not go to the surviving spouse, which then, because of longevity, the surviving spouse has a high probability of getting remarried. And with that I love you will, then that new husband or new wife is going to receive everything, and they have no legal responsibility to leave anything to the children of your first marriage. So if that's of importance, definitely listen to session number 2. And number 3, we talked about asset protection for your kids. You may have a spendthrift child. You may have a child that is chemically dependent on things. So we put that money in a testamentary trust. We have a trust protector on that. And we create a legacy of funding family vacations for 20 plus years. So again, if those are of concerns, listen to session 1, 2, 3. And what are we doing here on session number 4? Well, we're going to talk about asset protection on your largest financial asset. Now think to yourself, what is your largest financial asset? No, it's not your home. That is a physical asset. Your financial asset is going to be your qualified account. Yes, your 401k, your 403b. That is your largest financial asset. So how much asset protection planning have you actually done to that? Well, I can tell you, your 1-800 financial firm, your HR department, they're not going to give you any counsel and advice on asset protecting this largest financial asset in every household. Almost a 90% chance that that is a true statement. So with that in mind, what's controlling this financial asset? Could be $1 million, could be $500,000 within your 401k. Well, the simple thing that controls this upon your passing is a one-page document. Think about this. One page controls $500,000. Well, that one page is a beneficiary designation page. And think to yourself, who's the primary beneficiary on your 401k right now? Well, if you're in the car with your spouse, you better look at them and say, hey, you're it. You're 100% beneficiary. Gotcha. Okay, that's great. Who's the contingent beneficiary? Well, some people get in a hurry and they leave that line blank. Well, if it's blank, then it goes by default to the estate and you just lit the tax time bomb. We have 5 years from date of death to distribute this, no matter what your other plan is. You did it wrong. So here's my challenge to you as a listener here on the Professional Edge is make sure that you have a copy of your beneficiary designation on your 401k or your 403b or 457. It's any qualified account. So with that in mind, we're going to look at that very first page, and you probably named your spouse as the primary beneficiary. Got it. Now, if you didn't have a contingent beneficiary, let's update that and give the kids that. Now, there's 3 important words that you need to have after your kids. Let's say it's 50% child 1, 50% child 2. And 3 magic words is issue per stirpies. You need to add that on that contingent beneficiary line. That's going to protect you from disinheriting your grandchildren. So, all right, back to the front. You pass away. Your surviving spouse is going to inherit this 401k. Let's call it $500,000 for our conversation. So they receive that $500,000 in they're the beneficiary. They can roll this over to a spousal account. So a spousal rollover IRA. Now, lo and behold, your spouse gets married. Now, on that beneficiary line, the primary beneficiary line, now they have the $500,000 spousal rollover IRA. The primary beneficiary, well, they're going to sit down with his stockbroker in case that you passed away, gentlemen. She gets remarried because she is highly more attractive now because she has a $500,000 spousal rollover IRA that just made her that much more attractive. Think about it. So husband number 2 comes in and says, hey, you know what? We need to go see my stockbroker. He's the best, or she's the best on earth. And we're going to move this over to this brokerage account. And we're going to start working with my stockbroker. Well, that stockbroker is going to surely generate the account forms. And lo and behold, who's going to be the primary beneficiary on that spousal rollover IRA? Well, it's going to be H2 in this example. Well, H2, he survives your spouse. Guess what? H2 now has your $500,000 401k. And H2 has no legal responsibility to leave any of this to your kids. So think about this. Just based on your simple financial planning, you named your spouse as primary beneficiary, kids as contingent beneficiary. Well, we never got to the kids because the spouse put in that into a spousal rollover IRA and then got remarried and updated it to H2 as being the spousal rollover IRA person, not to the kids. And therefore you just disinherited your kids with a $500,000, your largest financial asset. It's simple. It's 90% of the people, 90% of the listeners on the Professional Edge have this. They name their spouse as primary, kids as contingent, and that's it. Move down the road. What's the alternative? Well, let's go ahead and create a designated beneficiary trust. What does that mean? Well, you draft a legal document. Being a tax attorney, we draft this, put that as the primary beneficiary on your 401k. Wait a minute. That line says the name of your primary beneficiary. Right, we're going to name your designated beneficiary trust as being the primary beneficiary. We want these proceeds to be controlled by trust terms and conditions. So therefore, the surviving spouse is going to have access to it. Yep, we're going to be required to do your required minimum distributions for the surviving spouse. But lo and behold, that surviving spouse is not going to be able to name H2 as the primary beneficiary on this for when they pass away. So the terms and conditions of the designated beneficiary trust says, yes, surviving spouse, you have access to it. Please comply with the required minimum distributions. But when you pass away, it's going to our kids in equal shares by law, by the terms and conditions of the trust. It doesn't matter. The surviving spouse cannot change, update, or amend this primary beneficiary on this designated beneficiary trust. You, the owner of that 401k, the $500,000, are in control of it today. And with proper planning, you can guarantee that your kids are going to receive the final balance after your spouse passes away by law. Now, got to ask yourself, okay, we cleared up one thing. We pulled the beneficiary designation on your 401k. We got a copy of that, and it says spouse first, kids second. So if it's blank, please do not say as primary beneficiary the estate of yourself, the estate of John Smith. That creates a tax time bomb of it's got to be all distributed within 5 years. We at least get 10 years, or we have a spousal rollover option. So those are key provisions. So do not name the estate of on the primary beneficiary line of your 401k. If it says my spouse and then the contingent beneficiary is blank, well, definitely update that to your kids right now. That will at least put a Band-Aid on this. But if keeping an asset protection of protecting your largest financial asset to where your kids cannot be disinherited. And we all know we're all living longer. People are getting married even in their 60s, late 60s and 70s. They're getting married again. And stockbrokers that are not aware of what's going on are 1-800-FIRMS. Yes, they'll send you the paperwork and fill it out real quick. Well, lo and behold, that marriage spouse, they've heard of the spousal rollover IRA that we can defer the payment of taxes on this. Well, it's simple and easy, but with that spousal rollover option, you just guaranteed the disinheritance of your children, of that $500,000 IRA that you worked 30 years in order to put away enough money for that account. Now, it's not your intention that you're going to give this to H2 or W2, the next husband or the next wife. That's not the plan if you're married and you have kids, right? So the only way you can guarantee that your kids are going to receive this is you, update your planning, your asset protection, and you have a designated beneficiary trust drafted by a qualified tax attorney, me being one of those. Yes, I'm raising my hand. And have that named as the primary beneficiary on your 401k account. Yes, we're going to supply that with the plan administrator, a copy of that trust. Yes, absolutely. They're going to look at you and say, this is not normal. Right, exactly. It's not normal, but it's very prudent to be able to say, you know what? When I pass away, my wife or my husband is going to be able to have the access to this account. But when they get remarried, if they ever do, I'm going to guarantee that this money's not going to that Yahoo. It's going to go down to my kids when my surviving spouse passes away. So if that's of concern to you, do give our office a call at 877-654-9798. That number again, 877-654-9798. Again, a lot of people don't do asset protection planning, and this is protecting the assets for the family, the Smith family or the Levinson family. It doesn't matter what family name it is. It's that you've taken the time to understand what transpires or what is a high probability of transpiring into the future, and you want to protect those hard-earned assets. Think about that. Oh, I'm sorry, Dad didn't really do that good of planning, and he left everything to Mom, and Mom got remarried, and Mom left all this to her new husband, and the new husband doesn't really like the kids of that first marriage, so he has kids of his own, so he leaves this 401k, which is your dad's account, to his kids. Wow, that's a tough pill to swallow. Think about it. Now, if Dad would have actually put in place a plan, have a designated beneficiary trust as the primary beneficiary on his 401k, Mom's going to receive the money. That's not a problem. But if Mom gets remarried, guess what? Mom cannot leave this to H2, the dodo bird. So you could care less what the relationship is, and he thinks he's going to get it. Well, you already know that Dad has placed these monies in a designated beneficiary trust. When Mom passes, the balance of this account is going to go down to the kids in equal shares, how Dad and Mom talked about it. Yes. So if that's of importance, give our office a call at 877-654-9798. That number again, 877-654-9798. I appreciate you listening to The Professional Edge, and yes, this is asset protection. We talked about liability protection from tenants. We talked about your surviving spouse, protecting them. We talked about protecting the kids from themselves. And now we talked about the largest financial asset. Let's control it, let's protect it, let's make sure it stays in the family. My name's Sean Todd, tax attorney, CPA, and certified financial planner, host here on The Professional Edge. I appreciate you listening, and if this can help someone else, send them the link to the podcast.
With today's financial markets, are you getting the personal and professional attention you and your money deserve? Clients of estate management counselors benefit from having one set of professionals advise them on their tax, estate planning, and investment advice. We call that the Professional Edge. Sean Todd is a tax attorney, CPA, and certified financial planner. With over 15 years' experience, he welcomes the opportunity to assist you in preparing for retirement, implement effective tax planning strategies, and to help you properly plan your estate. His radio show, The Professional Edge, is aired weekly on Sundays at 9 a.m. If you're interested in meeting with Sean, call his office at 877-654-9798. That's 877-654-9798. Do you want to feel more confident about making the right investment, tax, and estate planning decisions? Today, these decisions are more complex than ever. Have you thought about working with a professional advisor and not sure who to turn to? Not sure what qualifies one to be an advisor? Sean Todd is more than qualified as a tax attorney, CPA, and certified financial planner. Scene is with Estate Management Counselors. Estate Management Counselors operates as an independent fee-only investment advisory firm. They're dedicated to gaining a personal understanding of their clients' objectives and implementing professional counsel and advice to achieve those objectives. So take a second to talk with Scene Todd to learn how you can benefit from their multidisciplinary practice where they coordinate their clients' legal, tax, and investment strategies into one comprehensive and integrated plan to enhance and protect their clients' financial security. You can reach Estate Management Counselors and speak with Scene Todd by calling 1-877-654-9798. That's 1-877-654-9798.